Good morning and welcome. I thank you on behalf of the statewide ADR Commission and the Administrative Office of the Courts. Thank you for being here. Welcome to Santa Fe. We really appreciate your participation. This is something new, and hopefully it's one of many sessions that we can provide for all of you to help develop ADR programs around the state. My name is Mateo Page. I work at the New Mexico Administrative Office of the Courts. I am the ADR statewide program manager, and my job is to help all of you do whatever I can to help you develop your programs. So, and to help us with that mission, we invited Susan Yates, Executive Director of Resolution Systems Institute, to be here with us today, all the way from the Midwest, Chicago. So we thank her for being here.
All right, that's me. Hi. I am so excited to be here. I've been thinking about you all for several weeks now and getting prepared for this, so it's always exciting to finally see people in the room. Let me get the clicker here. I'm going to start with, greetings from Chicago. A little bit about me. I've been mediating for a very long time. A lot of my belief in mediation and ADR more generally comes from, for one thing, thinking that people can do a good job when they sit down and try and work out their own resolution. And also feeling like there's a lot of kind of wastefulness in unnecessary conflict, right? There's some conflict that people have to work on and get through and grow, but there's an awful lot of just wasted time and energy. So that's kind of just personally where I come from in terms of mediation. And then with court ADR, what I like is that I can take those ideas and make systemic change, right? Like, it isn't just me sitting in a room with a round table, but it's knowing that there are lots of other neutrals out there working with people and helping them reach their resolutions. Why rob banks? There is a famous, to me, quote from bank robber Willie Sutton, when asked why he robbed banks, he said that's where the money is. And so to me, the reason I work with courts is because that's where the conflicts are, right? If we really want to work with courts, with conflict, that's where we go. So RSI, Resolution Systems Institute, we're a nonprofit. We're based in Chicago, but we work nationally. Our mission is to improve access to justice by enhancing court ADR. We have a number of services. A resource center, which you're going to hear me refer to a lot, and a lot of the materials that you got in here are from our resource center. Things like me coming here and talking to you, this is all about our efforts to collect and disseminate reliable information about court ADR. So that's where we started from. We also do a lot of research and evaluation of court ADR programs. Right now, we're preparing to do a big evaluation with Pew Charitable Trust and University of California, Davis of online dispute resolution programs. So we try and sort of figure out where things are going and go with that. My love is dispute system design, the thing that we're going to be talking about today. I was sort of joking with my friends at home, like, I'm doing all this preparation, but I really could sort of roll out of bed and come talk to you about this, because this is like so much me and what I believe and what I've been working on for so long. Trust me, I did not just roll out of bed. I've got the binder to prove it. But and then we also have our own mediation programs that we run. We operate a couple of foreclosure mediation programs and a child protection mediation program in Northern Illinois. One of the reasons to mention that is that today I'm going to talk about what you ought to do, and you should do this and you should do that, and people talk about best practices. There's nothing like running your own programs to keep you humble. You can't do all of what we're going to talk about today. The idea is that you will have a structure, you'll be able to go back to your jurisdictions and have resources and ideas and have thought through things. But I know that we're all far from perfect. Now, a little bit about you. I had a chance to say to some people as they came in, are you sitting with other people from your jurisdiction? Is anybody not sitting with somebody from their, but you don't have a jurisdiction, I know, because I talked to you this morning. Yeah, and so we've got a couple people who don't sort of have jurisdictions, but for the other, because there'll be a few times during the day when I'll say, turn to the other people who you're working with and talk about this. We're not going to do big breakout sessions with flip charts, and we're not going that far. But I do want you to be able to talk with one another. Okay, so it always helps me to know who's in the room. Who are the judges? Okay. Court administrators. Mediators, other neutrals. All right. Lawyers. When people do this and I'm in a session, I'm like, I'm not in the, yeah, I mediate, yeah, I do this, I'm like, what about me? So do we have other, I know I talked to, yeah, so you're from county services? So they're thinking about how they might want to do ADR. Other people who feel like you were missed? Okay. Can you sort of generally tell me where you're from? Because I've been to Albuquerque a couple of times. I think this is my first time in Santa Fe. This is a very big state. It's sort of like people who go to Chicago and say, oh, I've been to Illinois. I'm like, I don't think so. Because I think there are a lot of similarities, right? Where you have like that urban center, and it seems like you've got a few urban centers, and then you've got a lot of other counties. Y'all have managed it. In our little state of Illinois, we have 102 counties, if you can imagine. So none of ours are anywhere near as big as what you have here. I don't know quite how to do this. So who's from Santa Fe? Let's start with that. All right, now this whole thing was sitting with your jurisdiction. I don't know what happened, but the two of you are at opposite ends of the room. And then who's from Albuquerque? All right. And then where do I go from there? Taos, you were from other...
A couple of us from Taos, 3, 4.
And then what would be the next?
Las Cruces.
Which is...
Down south, 3.
Oh, wow, yeah. All right, you guys had to drive.
We're the 4th Judicial District.
Okay.
Las Vegas, but not Nevada.
All right.
Then we're from the Four Corners, so the number 11, the District 11.
Great.
We're from the Pride of New Mexico, the 9th.
The 5th.
The fighting fifth. The nifty ninth, the fighting fifth. Wow, okay, so great. You really are from all over the state. Wonderful. I'm happy to see it, and I'm sure Mateo, wherever he is happy to know that too. So there's going to be a lot of information to pack into 3 little hour-and-a-half long sessions. You may just, I'm going to try and sort of have a through line, and we're certainly not going to be redundant from one to another. If you need to go to other sessions, understand, we'll make this work. You will get out of this whatever you get out of it when you're here. And the goal really is to give each jurisdiction kind of a framework where you can go back. You're not going to leave here with the plan, but kind of a blueprint, like what's the structure, what do we need to think about? We're going to talk about things like the issues to address and the questions to answer and pros and cons. And like I said, best practices. Someday I'll do best practices. You've got a ton of great resources here. We're not going to go through all those right now. We're doing these 3 different sessions. First, we're going to start right now with Design Your Program. We're doing a whole session just on working with neutrals because that's really the crux of court ADR. And then Manage, Track, Evaluate, Promote. So it's sort of how do we put this together? Who are the neutrals? And now what, right? Like, how do we actually run these programs is what that third session is going to be. And with that, I think we're ready to start the first session. So in this session, we're going to talk about things you need to think about, things you need to research, and then decisions you need to make. There are nifty materials there. So, characteristics of quality court ADR programs. The first thing is goals. Your jurisdiction, your leadership, your stakeholders need to have a common sense of why it is that you want to do an ADR program, what you want to get out of it. We're going to talk more about goals in a minute, but if you, right, it's that Yogi Berra quote, if you don't know where you're going, you might not get there. So figuring out your goals. Then there's some really foundational principles. In mediation, confidentiality. In ADR more generally, fairness of the process, fairness of the outcomes, procedural justice, quality of your neutrals. If it's mediation, self-determination, timely, there are those underlying touch points that you as a group are going to need to kind of identify. And then, I do not have a slide for accessibility, but there are at least 4 areas of accessibility that you're going to need to look at. The first is, what about people who can't pay for ADR services? How are you going to provide provide ADR to people who can't afford it? The second is, what are you going to do in terms of people who don't have lawyers? Some programs choose to exclude people that don't have lawyers. Some choose to only offer services to people who don't have. So kind of how you're going to provide services. I heard you, Judge McElroy, this morning talk about the burgeoning self-represented litigants who are in our courts these days. So accessibility for self-represented litigants, people who are disabled, how they're going to be able to have access to your programs, and parties who speak English, languages other than English, and how they're going to access it. So you've got a lot of sort of accessibility issues that you need to think about. Another is the process quality. Notwithstanding all these other things that we're going to talk about, if parties come into a mediation and they don't feel like they were just well served, then your program isn't going to work, right? So you need to think about what is that experience of being in the ADR process? How do they experience that as a quality experience? And what might be the touchstones for that? With mediation, with self-determination. For a lot of people with arbitration, it's about speed. We'll talk more a little later about the cost of ADR. And then again, the participants having this experience of procedural justice. So did they feel like they had a voice in the process? Did they feel like they were respected during the process? And did they feel like the process and the outcome were fair to them? But that doesn't mean that people walk out being like, oh, greatest thing that, but did they feel like it was a just process? And then the last of these topics here is program support. You got to have the people and you got to have the money, right? We're going to spend a lot of time today talking about who those people are and what that money might be, and where you might get it. But those, if you don't have that program support, you're not going to go anywhere. So now we're going to talk about why you might want to do an ADR program. And I think of why as being different from your goals. What I've seen, I've been working with courts for a very long time, and the impetus to create an ADR program it varies. We helped the court in Rockford, Illinois do a small claims program because one of the judges who's was in felony court. When she was running for re-election, she said, and if I'm re-elected, we're going to have small claims mediation. So she really felt like, okay, now I better go live up to this campaign promise. You might have new leadership in your court. You might have a new need, right? When we had the housing crisis, there were foreclosure programs that bloomed, foreclosure mediation or other kinds of dispute resolution programs that bloomed across the country. So the why you want to do this might be a little different from what your goals are. Does that make sense? They're probably going to overlap. I'm not saying that they're leagues apart, but so then the goals are probably going to be much more measurable. Do you want to shorten time to trial? Do you want to increase the number of settlements? Do you, with child protection mediation programs, often courts want to reduce the time that children are within the child welfare system and get them into a permanent home faster. So those goals, I guess, may overlap with why you're doing it, and those goals are what you're really going to need to articulate, because later, if you want to figure out if your program is working, you need to have figured out what you wanted to do in the first place. Let's talk for a minute about this. Are you going to save time and money, especially money? I think a lot of courts have assumed, and people working with them have assumed that if you will save money if you have a court mediation program. If you, say you put in place a divorce mediation program, and you're somehow paying the mediators, whether they're staff or whatever, if you still have the same number of judges in the same number of courtrooms, the same number of hours, and it's pretty unlikely that the court is going to actually save money. Think about what all those other values are, though, right? If it's a parenting cases, do you have parents who are reaching an agreement that is more durable? All of those things that you might do. So before we just sort of say, oh, court ADR, it saves money. And I say that in part because our director of research at RSI has read and evaluated all of the evaluations that looked at this question. And her answer is, does court ADR save money? Her answer is sometimes. And we've got a whole section on our resource center if you want to look at those studies. So now what I would like, you remember I said I want you to kind of spend a little time in some small groups. Talk a little bit about why you're doing ADR and what your goals are for it. And I'm talking about 5 minutes, right? So this is just sort of a quick check-in. Go.
Actually, I think our program does
Okay. If you can come back to the large group. I'm curious about as you had these conversations, did your goals seem to be different from your reasons for ADR? Did they overlap? Oh, you nodded at me. That means I'm going to call on you.
They kind of overlap in the sense that the goals are making sure that the topics are reduced in size, at least in some respect. Also, just make sure the parties are satisfied with the results, rather than sometimes when you go all the way to trial and get a decision, one side is very unhappy about the result. It works out a lot better if both parties agree on the result.
So people are happier, and the dockets are slimmer. What other kinds of goals? Mr. Levin?
When you talk about saving time and money, and the fact that the court staff
building, electricity and water will still stay the same cost. There's another economic measure of the capacity of the courtroom. Because if you have a court that's designed to handle 1,000 cases, and they have 1,500 cases, and mediation can remove even only 100 cases, then there's an economic saving that is less directly measurable than having less staff, less water, less electricity. And I'd love to have Jen address the research director.
Well, and when I was first doing court ADR, I worked with a wonderful judge in Rockford, Illinois. You know, silver-haired, he looked like he should play a judge on TV. And he said, you know, we've got to do civil mediation over here because I need my judges in family and in criminal court. And he said, you know, I would get new judges and we'd be walking them around and, you know, we'd walk past the civil courtrooms and say, look at them now because you're not going to see them because this is where I need you, is in family and in criminal. So that, you know, where are the pressure points? And I think we saw that with foreclosure mediation, right? These cases, you know, they just blew up the dockets. I don't know, that's what I saw in Illinois. Did you have that experience in New Mexico? No. And I think this sort of goes in the category of why rather than goals, but the judges in the foreclosure mediation courtrooms were sort of at the top of the pecking order, right? They weren't doing traffic, they weren't doing children, they weren't, you know, they had gotten to kind of the most respected area of the court, and they had all these self-represented litigants like crying in their courtrooms, and they were like, this is not the way this is supposed to be happening here. So yeah, sometimes it's about numbers, and those numbers are hard to quantify all the time. What other kind of goals and reasons? What about this crew back here? Where are you all the Albuquerque people?
We're all the foreclosure people in Albuquerque. And
Wow. And so are these things that I'm saying about foreclosure, are these ringing familiar with you? So from that experience, what would you say to everybody else about them starting ADR programs?
Well, we had just discussed that, as you had said, due to the foreclosure crisis, it began inundating the courts, and it already inundated court system. And so in order to try and relieve some of that pressure, not only from the judge's docket, but also to simplify a process that does not need to go through litigation every time. So out of this necessity, these programs were created, and they serve a very important function within the judiciary, because without them, the judges aren't able to focus on cases where there really needs to be a lot of time and attention paid, specifically to cases that involve mental health and incapacitated representative or litigants. And so it's very important that these programs exist to help the judiciary, specifically the judges and their dockets.
I agree, and what I saw with these programs was, if you looked at these just as court cases, they were losers for the homeowners, right? They hadn't paid, and they were deeply, if you just went through the litigation process, 90% of, not the right number, but a huge percentage were just going to lose their homes. Whereas if you had this other process that the banks also had to they all had to get up to speed on this too. But if you had a way to really look at loan modifications and figure out what could happen, some people could save their homes, and the people who couldn't felt like they at least understood it. They got why this was happening.
It's frustrating to me because as a judge, and a chief judge who had to manage budgets, I'm well aware that programs might save money, might have better results. I'm not sure that those are two things you're looking for. But it also costs money. It takes resources. And I think that we've seen the success in the foreclosure mediations because after 2008, 2009, when courts were inundated and the Attorney General's office had money available, so they gave $250,000 or $500,000, $600,000 to some of the larger metro courts that were able to use the staff, and they've created a very successful model. And then I'm looking at the rural courts in New Mexico, who, you know, half of a staff person's time is like a big commitment.
Right.
And they really can't do that much. And so I was even talking to, we have basically almost 0 cases mediated out in the civil realm in the rural courts. And in the urban courts, I had a meeting with the urban court staff last month. And I thought, well, you know, these are the big boys, they're going to tell us how to do it. But they're only doing 1% to 2%, maybe 5% the most of all civil cases. In Taos, our district, we have 900 civil cases. So my thinking was if we could do 10% in 1 year, that would be 90 cases. And I think it's not so much because it would save money. That's not going to represent a whole new judge that you don't need.
Right.
But I think you end up probably with better results on those cases if they're resolved quicker and through mediation. But we don't have the resources. We've been trying now for a year or two to get to that 10% figure. And we're lucky to do 10 cases a year.
Yeah. Well, and we will, thank you. Let's talk about that today.
Well, that's
You know, I mean, that's-
frustrating to me because
No,
you
you're-
you talk about saving money, but the fact is it costs money, but then we don't have that money committed
Right.
to the courts that we need, with the exception of the civil. And, yeah, Aaron?
No, and I was just gonna piggyback onto that, Judge, and say, I mean, and that's true. I mean, and even we talk about the foreclosure program, but our funding is up in the air. So it's like we spent these years building this program and our funding is set to expire. And then it's a scramble of, well, what do you do at that point then? How do you maintain a program that you put all of these resources into building and trying, you know, in our directive, like, okay, let's take it out to the state, but then you're left without resources, and I think we're in the same position then. And then it seems to me it's almost a harder hit on the court too, because then, you know, in our district, then our judges who are used to having this relief in their docket are going to be seeing, if all of these cases get put on their docket, that's going to be a big hit because, you know, those gaps get filled with other types of things. How do you rearrange? So I think it's a difficulty.
So you've just surfaced like the theme for the day, right? And I'm not going to say, so here's the answer. What I'm going to say is here's the process, right? What can I say? I'm a mediator. I believe in the process of how you all are going to figure out the answer. Anything else about goals and reasons?
Oh, there is, hi, I'm Maggie Reynolds, and I'm the magistrate coordinator for the southern region, I guess you'd say. I've got Clovis, I have Alan Bordeaux, and I have Diamond. And what I've noticed is it may not be a specific goal in mind, but the people that go through mediation in our court seem to come out with a little bit better understanding. I've talked to some of them because every once in a while they'll stop me and say, I didn't understand what's going to happen. It worked really great. Thank you very much. And I've asked those people if they think about it for a couple of days, if they wouldn't mind giving me a call sometime and just tell me what they think about it afterwards. And a lot of times they'll tell me they felt like they were more part of a community. I didn't ever hear before, but I've never asked anybody to call me afterwards either before. But they will tell me, you know, they feel like they were more part of a community and they felt like they made a better connection. And that's something that magistrate courts normally don't even think about.
What kinds of cases do you have?
We do just about everything that the judges will give us. Sometimes it's ordering on maybe a criminal case, somebody stole something from someone, and sometimes it's just, you know, somebody left without paying their rent, or, you know, it could be all kinds of things. But they're talking about being heard in a institution, and it makes a difference. And
Magistrates are very small claims courts.
yeah, it's mainly anything under $10,000.
Right, so that I think it was somebody in the opening session this morning was talking about our courts kind of shifting, maybe it was you if they were talking about courts, Judge, shifting to more of a kind of customer service approach, right? Do you want people to leave feeling like, hey, I just got a good service from this big aspect of the court system? In order to get there, you're going to need to look into a couple of things. The first is, what are your rules? See, I told you there wasn't going to be anything magic in these slides. They're just like, okay, let's talk about this next. What's the law? What are the rules? What is the environment within which you're operating? And there are, right, New Mexico Supreme Court mediation guidelines. Mateo, is that the, what kind of guidance do you find in there that is going to either encourage, what? No, you're laughing. Yeah. So what's going to encourage mediation? In Illinois, if a judicial circuit wants to do a mediation program, they have to write rules and then get them approved by the Supreme Court. Do you have to do that here?
Yeah. If we want to implement any sort of local rule before we can actually implement it, it has to be reviewed by the Supreme Court.
And do they do that quickly? In Illinois, it's a very opaque process exactly how that happens. So the point is that you've got materials in your book. You need to look at what is the context within which you're operating. Then the other thing is, what is the ADR culture in your community? I've been in this field for a very long time, and so I have seen communities go from not knowing what mediation was to really having mediation, civil mediation, ingrained into how they operate. I've seen it happen sometimes that a jurisdiction will really rely on their family mediation program, but somehow mediation doesn't seep out into the other areas. So what is your sense from your different area? So you've got all this foreclosure going on in Albuquerque, and that's where the Metro Court is too, right?
Yeah.
What else is in other areas, what is your ADR culture?
Yeah.
The state recently revised the guardianship statute quite a bit. And so I had testified, and some of us had testified about trying to get mediation as part of a guardianship once the petition is filed. Mm-hmm. And even if you only mediate some issues, so we've made our presentation. It's myself, Robert Rambo, and then Lori Millett, who's not here today. But we're all three attorneys, and Lori specializes in elder law. Anyway, we made a presentation to the 13th to Aaron, and they're considering that right now. But so I think, to me it seems like the state taking the initiative to improve upon that guardianship statute, I think that kind of gave us the impetus to really formally start asking for mediation in these cases. And then we want to try to get a sliding scale. This was actually Aaron's idea, so that the people can pay according to their income, but just only a percentage of what the mediators charge. So it's court connected and court sponsored. So the culture, like you're saying, is really important, because I think the culture kind of shifted once the legislature started revising that guardianship statute.
Well, and so who is taking the lead on that, right? So is it that the legislature is changing something, and then in your local area you say, oh, hey, we could change this too? What I have seen some places is that you'll have not quite a rogue judge, But a judge who sees a problem and says, I want this to be different here, and we're going to try this, we're going to do a pilot program, and not necessarily be kind of concerned with what the rest of this. So it can be bottom up, it can be top down, it can be side to side. As you do that, though, part of it is figuring out who, and we touched on this very briefly, but who are all those different stakeholders then, right? If you are talking about elders, do you have advocacy groups that specifically work with elders who need to be at the table, both because they know the most about what the issues are that elders and their families are facing, and because if you don't have them there, they're not going to accept the program if they're left out, right? So there are lots of reasons that you need to bring these different stakeholders into your process of developing the program.
I think the actual existing culture that exists in New Mexico is, with regard to civil mediation in courts, is to do anything they can to avoid being involved in courts. So it's all outside the courts. It's private mediators, it's attorneys that people know, that everybody tends to go to. And because I'm looking at, if we set 95% of all cases settle, or even more, and only 2 or 3% are being dealt with in the larger courts through civil court-connected mediation, then that leaves about 90% of the cases where either people are finding their own way to resolve through other mediators, or they're just languishing until they give up, and then they just settle the case because they don't know what else to do. And so I think the culture of that 90-some% of the cases is what you need to look at. And I think that for the most part, those are to do everything they can possibly do to avoid being involved in the court.
Is that what people are seeing other places, that people, that the lawyer, so it sounds like the lawyers are getting together, putting their heads together and saying, let's go hire so-and-so to help us sit down and figure this out?
No, they do it themselves.
Oh, so it's just bilateral negotiations.
Well, I think there's an industry, though, of attorneys particularly, that are considered to be, and there are probably 20 or 30 that most people in the room could name, that are considered to be the ones that are the go-to folks. And so then they just try to follow up and figure out time and resolve it. I think a large percentage of the hiring cases get resolved that way. Or the attorneys do it themselves.
And is that true in other places in the state?
Yes, that's true for Las Cruces. That's very true.
And so some of that is the two lawyers get on the phone together, wow, like lawyers used to do, right? And say, let's sit down and work this thing out. And so that's one model, and the other is let's go hire former judge so-and-so to help us work this out?
But if that's the large group that have attorneys, what I, at least in the 8th, wanted to try to figure out is what about all those cases that either don't have attorneys, they're in pro se, or they can't afford to hire, a $200, $300 an hour mediator, and how do those cases getting resolved? And right now, I think as a judge, what I see is they get resolved through exhaustion, because they get to the point where nobody's doing anything, and they finally give up, and they may reach an agreement, but it's not a satisfactory one, because courts have taken a year to get it to a settlement conference, and not a settlement conference, but scheduling conference. And a year has passed, and by now they've kind of lost interest. And so my goal would be to try to focus on those 20-30% of the civil cases that seem like they need help. I was just talking to Angela, and it's like, well, what are the low-hanging fruit that we could find to get up to those 90 cases? And we don't know for sure what those cases would be.
Low-hanging fruit, so low-hanging fruit, good place to start. A specific case type, elders. There was one other, it escapes me. But I mean, what you're hearing is like, here are the ways that jurisdictions decide how they're going to tackle this, right? Some say, well, if you don't have this culture of the lawyers call each other and they either negotiate or they hire somebody, if you don't have that, how do you support an ADR culture? But then, then those cases with high price, my personal opinion, The cases with high-priced lawyers are going to be dealt with, and they'll be okay. What happens to the cases below that? Now, those folks need their service. I'm not saying they shouldn't be served, but what happens to the cases, as you were saying, where one side doesn't have a lawyer? Those are really tough, right? And the other side is trying to even figure out like what's going on, right?
Well, I have, and I'm just saying, my jurisdiction's a lot like Judge McElroy's jurisdiction. It's rural, lots of people who cannot afford to have their own attorneys, and we've seen a huge increase, and I think it's probably true of statewide, huge increase in parties representing themselves. And so, sure, in the cases where we have attorneys on each side, which are more of the malpractice cases, tort, high tort cases, it's easy to set a scheduling order and say, this is your mediation deadline, get together, agree on a mediator, and
Do it.
get it done.
Yep.
When you have a landlord-tenant case that's been appealed from magistrate court or some other type of civil case where there are no lawyers and they're all self-represented litigants, you can say, okay, I want you all to go to mediation, and they look at you and say, well, what does that cost? And we can't afford it. They can't afford a lawyer, much less
Yep.
a mediator. So then you think, well, maybe I'll start making some phone calls and get
Twisting some
volunteers.
arms to get some, yeah.
But then it's a problem of, in like our area, we don't have mediators. We don't have many people trained in mediation. So I have to think of, all right, well, when I went through the mediation training, maybe I could call the people who trained me to see if they could maybe give me some names.
Yep.
And,
So can I ask,
so it makes it tough.
Yeah.
when you guys, I'm sorry, I'm not part of the course, I'm just here to help. I'm trying to get into it, I guess. Can I ask, when you say be live resources, is it actual mediators, bodies in the states? Okay, I want to give you my card. Pro bono
Well,
mediators.
and that's one of the things that we have others on the commission who taught me, that there are so many people in the community, even in the rural communities, the rural counties, that want to do this, whether it's at magistrate court or in the district court, that if we just figured out a way to reach out to them, whether we ask them to do it for free or we do a contract, and we now have a sliding fee scale where courts can charge the litigants an hourly rate that helps pay for that, plus we collect $15 a case for dispute resolution. So there are a lot of people, I think, in the rural courts that just, maybe they're not lawyers, but they're well-trained mediators, that, or even lawyers who are looking and eager to.
Sometimes even lawyers can do this, you know?
Yes, former lawyer.
One of the things that we're looking at is we're able to get some funding for a lawyer, and we just hired a lawyer for the court, and he's on his way to mediation training so that we can somehow be able to provide that service and maybe not have it be expensive to the public.
Great, so in the next session, we are going to talk about all these things you're talking about, everything from volunteers and what does it take. I began mediating as a volunteer, mediating these small criminal cases that were theft or criminal damage to property between friends and family members, right? So I believe in the power of pro bono mediators all the way through, can you find a staff person or a half a staff person? And then how do you leverage for the very rural areas? Like in Nevada, they managed to provide child protection mediators throughout that state, which is just phenomenal to me. So, there are models, and it's a matter of figuring out what are your resources, what can you do, and what are your needs. On the specifics of the mediator part, though, we're going to spend a lot of time on that. Before we get there, I want to talk a little bit, going to move from researching to the decisions you're going to need to make. So the first big, huge question is what kind of cases? And we've begun to talk about that, right? Do we care about the really big civil cases where everybody has lawyers? Do we want to take sort of the mid-range civil cases and figure out what to do with them. Do we want to have sort of the lower end? I'm talking about this all sort of in terms of dollar amounts. What are the kinds of cases that we want to do? And generally, courts start and say, well, let's do everything in this slice. Even if you say, let's do everything in this slice, you're still going to have some exceptions. Like our federal court in Northern District of Illinois, actually it's the appellate court, so the Seventh Circuit has an amazing appellate mediation program, but they still don't do prisoner civil rights cases or cases with about like federal benefits, right? So they have taken some and said, we're not going to do this. Now, you can do that. You can do the flip side of that and say, we have so many prisoner civil rights cases that we need a special mediation program just for those. So thinking about what kinds of, what are the subsections within is important, sort of what you're going to exclude, what you want to include. I talked about above or below a certain dollar limit. And then the other thing is, even if you have a pretty broad swath of, say, civil cases, what I have seen is that sometimes you, in all your civil cases, the biggest chunk might be personal injury cases. Not the big medical malpractice, but sort of lots of car accidents and soft tissue, and so you may get mediators who are really good at doing those, but then in that same sort of swath might be some real estate cases, right? Or I'm trying to remember some of the other kinds of little corporate cases that somehow seem like they're in that same group. So even if you look at this from a dollar amount, you're still going to need to think about what are the different kinds of cases that we typically see come in order to figure out what your mediation or your ADR program should be. We're talking about elders. Some courts say, let's focus on cases where there are family members involved, right? And so, then that's not just parentage, that can be, or parenting, that can be elders, it can be children who are wards of the state or who are now in guardianship. Do you want to think about that, who are the people who are involved? I'm throwing out all these different kinds of categories just for you to think about, what kinds of cases do we want to start with? Some say, we don't want to do anything where people don't have lawyers. Others say, we only want to do things where people don't have, so what do you want to do about legal representation? Because mediators need an extra set of skills if they are going to work with people who are self-represented, right? So those decisions that you're going to make about your mediators are going to vary based on what kinds of cases. And give me a case with two smart lawyers and everybody's being paid and they're paying me to come and mediate. Sure, of course we're going to get that settled, right? Give me a couple of people who are self-represented and who have just been mad at each other and they've been neighbors for 12 years. Those people are going to be hard to help them find a resolution. So there are different kinds of skills that you're going to need depending on which groups of cases. So let's talk about this next. Let's break up into your little groups by jurisdiction and talk about really within within whatever swath of cases, what do you want to include? What do you want to exclude? Does that make sense? bring the whole group back together again. We could talk about this for a long time, obviously, but what I wanted was for you all to get sort of a taste of this, and you're going to have a whole bigger group that you're going to need to talk with when you get home, right? So at least your smaller group here will have had some chance to think this through, and then you can talk with your colleagues. Now, what ADR process is best for you? I want to talk about 5 different factors. The first is ADR going to be mandatory? Now, a lot of people will say, mediation, it's a voluntary process. How can mediation be mandatory? To my way of thinking, you can mandate that people go to the mediation. You're not going to mandate that they reach agreement. I'm actually a big believer in mandating that people go and at least try mediation, because otherwise, what I have seen is that it's really hard to get programs to succeed if there isn't a big push. Sometimes, I know with our foreclosure programs, it is only mandatory, like if the homeowner goes in, then the bank has to participate. So you get those sort of back and forth about what's really mandatory. Then the opt-in cases, don't do opt-in case. I'm sorry, everybody thinks mediation is a great idea until they're in conflict. And then they want to win their case, right? So as much as we can all sit here and believe in dispute resolution, people are not going to opt into mediation for the most part. You'll have a small section, right? But you're not, so I never advise that people do an opt-in. There is, however, something that we call an opt-out. And that is where it is assumed that people are going to go into mediation unless they do something to not, or into ADR, unless they do something to just not participate in it. That's what we have done with some of our foreclosure mediation programs. So people were told, here's the mediation program, here's how you do it. But if they did not want to pursue that, if they just wanted to go down the homeowners, it was fine if they wanted to do that. So, so there are different ways to think about this. Just don't expect people to just say, oh, mediation, it's wonderful, I'm going to go do that. Now, is ADR going to be confidential? No, confidential. In mediation, it's confidential, but you've got some exceptions, right? I mean, if somebody threatens the other party in the mediation or something like that, you've probably got some exceptions that you warn people about. But there's an assumption that the typical mediation is going to be confidential, and that especially the court is not going to know what happened in that mediation, right? The judge, when you go back in there, is not going to be told, here's what my last offer was, here's what the last, you go back in and you sort of start fresh, right? So there's that assumption of confidentiality in mediation. In arbitration, you're going to have to figure that out, right? Are your arbitration, so court is an open process, people can come and watch it. Are your arbitrations open? Probably not, but is there a court reporter there? Probably. So figuring out what you want to do in terms of how you deal with confidentiality is important. Do the neutrals make any decisions? No, of course, if you're a mediator, you don't make any decisions. If you're an arbitrator, you make decisions. But if you're a mediator, you make a lot of decisions about the process, right? You say, now I'm going to talk to you, now I'm going to talk to you, now we're going to not do this anymore because, this isn't working, right? The mediator does a lot with the process, just not with the outcome. The parties have control over the outcome. The arbitrators have a lot of control over the process, right? Here's when you need to present material, and here's when do you need to show up, and here's the hearing, blah, 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 and here's what we're going to accept as evidence, and about the outcome. But is your arbitration program then binding? you have some arbitration programs here, right?
I've never heard of courts having an arbitration program within the courts programs. Is that common?
We have an arbitration program.
Oh, yeah, that's true. Albuquerque, of course.
And is the decision is it a panel of arbitrators or a solo?
It's a solo arbitrator. So if attorneys who are a part of the State Bar of New Mexico who are active, if they have 5 years or more of practice, they're automatically put into the arbitration pool. So they're selected randomly, and then they're the arbitrator in the case, and they get to make the decision.
And then is their decision, it's not binding, the parties can go have a trial if they want?
They can appeal it. They can appeal the decision by the arbitrator if they want.
Wow, do they actually need to go to an appellate court to do it?
They can, I think if they appeal it, it goes back onto the judge's docket.
Yeah. Yeah, it's rare. Illinois has a non-binding arbitration program for those middle cases, right? Not the great big civil cases, but not the small claims. I think our small claims is 10,000, and then the upper limit of arbitration is now 60,000, I think. So and we have a panel of 3 lawyer arbitrators, and they have some pretty minimal training that they go through. And I don't know if you've been doing your program for a long time. Our programs have been in place for a really long, like they started before mediation. They go back into the 70s. And the idea, which was a good idea, was that you would have 3 experienced lawyers who would hear from the 2 sides and then say, basically, here's what we think your case is worth. Kind of what we're thinking about now in terms of more like early neutral evaluation. But it hasn't really worked out that way because the arbitrators are not necessarily knowledgeable about the specific area of the law. And they may not be knowledgeable about sort of how that kind of case. Don't ever show this video in Illinois, okay? Because I will say, lots of places it really works, right? That the parties get back this case, get back the decision, and they may still negotiate after that, but it has given them a place from which to negotiate. So those programs can have a lot of good benefits. They're trickier to try and figure out really exactly what the benefit is going to be and how that's going to work and what you're going to need in terms of knowledgeable arbitrators.
I need to say, just challenge that just a little bit when you say attorney arbitrators. I serve on 4 different national groups. I'm not an attorney, but I arbitrate on panels for them. And their studies show that more and more when the parties are asked to pick an arbitrator, more and more they do not want attorneys on those panels. You want to make a comment about that?
Yeah. So are these like trade group kind of? What kind of? Are they secret arbitration panels?
No, it could be financial.
Like FINRA kind of things? So you have, which I kind of think of as a trade group. So you've got financial, you've got automotive. I sat on the Ford Consumer Appeals Board for a long time. I don't know what, so there is construction, sometimes mobile homes. So there are kind of trade-specific entities where I think the arbitrators can be very useful. That's outside of what I'm thinking about in terms of the court programs. And I'm not a lawyer either. So I'm not,
Specifically with a group of, a large group of people in the legal community, if they stay in their minds all this thing, you have to be an attorney to do this.
Yeah. So I'm happy to go down that path with you. I was talking about lawyer arbitrators because of the need for substantive knowledge of the particular, like I learned an awful lot about cars. I was the process person there with all these gearheads. I was like, all right, I can look at the paint and see if there's a problem with that. So with an arbitration system, you need people who know more about what the particular type of case is. They may have gotten that from being a lawyer working there or from right? So my colleagues on the Ford Consumer Appeals Board were the deans of automotive mechanics at local community colleges. So we didn't need to be lawyers to do that. The tricky thing, but those are they're created under Magnuson-Moss and Lemon Laws and all that. But when you're in the court system and if you're trying to do an arbitration program that covers a wide swath of different kinds of cases, figuring out how to have a roster of arbitrators who know enough about those case types to provide awards that reflect what somebody would probably get if they had gone to trial can be a challenge, figuring out who those people might be. Looks like we're going to be talking at lunch. Good faith. Okay, anybody here opposed to good faith? But putting a good faith requirement, especially in your mediation process, sends you sliding right down a slippery slope, because whether or not the parties participated in good faith is a decision that if you have your neutral, I say neutral because a mediator can't really make a decision about. They can make a decision about something very objective, like the parties showed up, or the parties sent their materials on time, and you can have a checklist of what is good faith, but once you get into those much more subjective, because I walked out of some foreclosure mediations and I was like, this bank was not ready to do anything in here, but that didn't mean that I, as a mediator, was in a situation where I could decide that that's what had happened and that therefore certain ramifications should occur. So I strongly suggest that you not have good faith requirements that are subjective if you want your mediator, if you're using mediation. Some programs, I think it's Hawaii, in their foreclosure program, they specifically called it a dispute resolution program, not mediation, because even though they did a lot of mediational things, they also required that their neutrals make decisions about good faith participation. So this is really, these two go together, whether the neutral is making any decisions and this good faith question. Despite my best efforts, I've had courts that have put good faith requirements in, and then you get to the situation where somebody is saying, well, this is not good faith, and the judge says, well, now we're supposed to have a hearing about whether, what happened, and what about confidentiality, and so what can seem like a really good idea doesn't play out well a lot of the time. Yep.
We have sort of a good faith clause in our mediation program with the magistrate court. They have 5 years. We give them 5 years after both sides agree. They can have a 5-year plan that if things do not go well, then they can go back to court and it goes back to the judge. But it's not, did they actually come in and really want to work and all that sort of thing. But it's kind of a good faith clause.
Well, it's a way to address it, yeah.
The judges have been very kind to come back and say, make this about money and not about digging ditches or anything physical somebody has to do. So it really helps us in the long run. It does kind of make people want to finish it and do what they want to do. It's sort of a good faith clause.
Yep. Well, and years ago, when I was still in the community mediation program, there were parties who, it was a tree, right? Anybody here mediate tree cases? Oh boy. And one party said, oh, the other party didn't do that. Well, and they said, well, that mediation agreement, that's a contract. And if it's a contract to perform, then you need to go to chancery court. And they end up, and they've got to file hundreds of dollars in order to get into chancery. the judge ended up saying, you know what, go back to mediation and sort this out. Which somebody said, there's some great quote about the only good cure for democracy is more democracy. Kind of the only good cure for mediation is more mediation was the thinking then. And some, in terms of, okay, oh, now we're down to binding and non-binding. Whether the agreement is binding or, you know, we just talked about that with arbitration decisions, whether or not they're binding. With mediation decisions, typically they are because both parties are agreeing to them. Often, not often, sometimes there will be review periods where the parties can go and have somebody look at it or just think about it. The mediator, so the dispute designer in me is like, yes, you should have that opportunity to review it and think about it. The mediator in me is like, no, they were in the room, they agreed to it, just make them do it. So there you go. So the mechanics of your ADR program. Usually you're going to figure this out by writing local rules. I mean, that's been my experience, that when a jurisdiction decides that they're going to do some sort of ADR program, some small group gets together and starts writing rules, which is a great way to do. You don't want everybody in the room writing the rules. You want somebody to go out and write a draft and then distribute it and get input and then come back. No group drafting, that's always a way to lose your mind. But you need to figure out things like, how are cases going to be referred, right? So earlier we were talking about what kinds of cases. Well, how will they be referred? When somebody goes to file their small claims case, will they receive something that says, you know, your case is going to go to mediation and this is how it's going to go? Will they get something that says your case is eligible for mediation? Will they not know anything about mediation until they show up in court? And then the judge says, oh, and by the way, we've got this mediation. So how are cases going to get from being filed with the court system into whatever your ADR program is? We're not talking about all those specifics today. I'm just telling you that's something you're going to need to think about. When in the life of the case is it going to go? So with civil cases, sort of what we have said is you want cases to go when there's enough discovery that people know what their case is worth. Now, this is when you're talking about lawyers representing people. But they haven't done so much discovery that they're ready to go try the case, right? When you have people who are self-represented, figuring out when to do mediation or, you know, can be trickier. And you probably want to decide that based on, you know, is it the first time that both parties have shown up in court? But even then, you've got the mechanics of, you know, is the judge going to say something? Lots of mechanics involved there that go back to that whole mandatory, optional, opt-in question. What are the timelines going to be? These are especially good when you've got two different groups. Again, I go back to foreclosure where we had homeowner people and bank people, and they always wanted there to be short time frames for the other, you know, hold that other party's feet to the fire. So, you know, figuring out what your time frames are going to be so that the cases keep moving forward, mandatory or voluntary. How involved are the judges, the lawyers, the parties? We had some programs in Illinois, these sort of major civil programs that really depended on the judge encouraging individual cases to go try mediation. You know, we had a roster of mediators and we had a process and all that. What we found was that there was sort of a bell curve, and some judges sent everything. Some judges didn't send anything, and then we sort of had the ones in the middle. But when that judge who was sending everything and a judge who was sending a lot, when they retired, we just about lost that whole program, right? So if you have a program that relies on individual judges to do the referring, there are a lot of challenges there. You've got to be ready when you've got judicial turnover, and you've got different personalities among your judges, right? The ones who, not only personalities, but just sort of beliefs. I've known any number of judges who said, my job is to hear cases and make decisions, and it's not to send that off to somebody else, to subcontract that. This is what I'm here for. I'm not sending it. Okay, they have a rational reason for it. So having a system that really relies just on the individual judge to refer has a lot of weaknesses built into it. But it may be where you need to start. How are you going to communicate these mechanics? You're going to write your rules, other procedural descriptions, and there's a whole chapter 10 in your materials about that. And then, what's your budget and where are you going to, you can see it was like Sunday afternoon. I was like, oh, I need to have some images in this PowerPoint. So what's your budget? Where are you going to get the money? And that's what a lot of you were talking about, right? Let's first, what do you need to spend money on? Case management, right? Somebody has to be sure that the cases are flowing in and through and back out from ADR. Are you going to need to hire trainers to train your mediators? What we did some places was when RSI was more flush, we would come in and we would do a free training for like the leading lawyers in town, and then with the agreement that they would mediate a certain number of cases in the coming year. And it worked really, it sort of jump-started these mediation programs. And these were these major civil cases where the parties were paying the mediators. So trainers, administrative systems, support to mediators. We talked a little bit about volunteer mediators. If you're going to have volunteers, then you've got a whole different set of expenses, right? Are you going to bring them all together, give them free CLEs, feed them pizza, have conversations where you debrief particular cases? Are you going to have an annual volunteer recognition event? Do they all get really cool cups that have you? Yeah. So figuring out what those expenses are is the first side of it. And then the other is, where are these funds going to come from, right? Where do your court funds come from? Is it all filing fees? Is it state legislature that apportions money to the courts?
We're going to try to get filing fees and then matching funds. We're going to try to see if we can get some grants and things like that.
Yeah, especially if, when you're talking elder, you can find some grants. There are federal court improvement program funds for cases that deal with children in the child welfare system. There are these different ways to go about that. It sounded earlier like getting the resources, especially in the smaller, in the more rural and therefore more sparsely populated counties was a big challenge.
We have $15 filing fees for civil cases. So if you have 900 civil cases, you get about $13,000. So what can you do with $13,000? And one of the things we worked on at the commission over the last couple of years was to get the legislature passed, allowing us to charge litigants a sliding fee scale so that if they pay some portion of the cost of the program, so if you're hiring or paying for mediators or your staff, then you can pass that cost on to the litigants. So those are really the only two sources that legislature's been stingy about giving money for these kind of programs. Recently, they appropriated $400,000 for ODR programs, and many are saying, well, gee, what could we have done in the courts for $400,000?
What cases are going through online dispute resolution in New Mexico? So is that part of that, sort of the small claims that are going over to?
Magistrate and district. And there's mostly been a pilot project with some of the courts that are here were part of the pilot project, and they've been doing it for a while. And then others of us just started in the last few months.
So we could go down the rabbit hole of like, is that really going to reduce costs? Like in Utah, as I understand it, they, like the front door to get into their small claims now is all online. You don't go to a clerk's office, so it kind of fits in with the whole, you all do e-filing? So it's part of e-filing, and then you have, for self-represented litigants, you need to have a portal that helps them understand how this all works, and courts all over the country are experimenting with online dispute resolution.
The Supreme Court, through our unified budget process, has supported staff attorneys with the courts, because most rural courts didn't have them, and the fourth and the eighth just hired them. The ninth has had one for quite a while. Ben's here, and he's been kind of doing a lot of the staff mediation, attorney mediation programs. So some of the rural courts are modeling on what the ninth has done.
Well, and for the very low volume cases, I'm thinking about the folks in Nevada that are doing child protection mediation, and they have little cells of mediators trained around the state, and still, I think they pay maybe $300 a case, and these folks go out and mediate the cases, and I think they get paid travel at a certain, depending on how far it is, and so part of this is just crunching the numbers and figuring out, if we think we want to, get 100 cases out of here and mediated somehow, or 1,000 or 10,000 or 100,000, what is that going to cost per case if we are paying people, it's time to get those spreadsheets going. All right, hey, we have 1 minute left. What else would you like to talk about what we've been talking about this morning? And remember, our first thing after lunch is talking about all these questions about neutrals and where you find them and how you train them and all that. Anything? All right, well, thank you all. This was great.